ABCs of the UCCs notes from the book. Taken by A.G. Middleditch on YouTube. Articles 3 and 4. Negotiable instruments and bank deposits and collections and other modern payment systems, respectively. The law embodied in Articles 3 and 4 of the Uniform Commercial Code has its origins in the Middle Ages. Merchants traveling to the great fairs of medieval Europe could not risk carrying gold and silver coin along dangerous road and sea lanes. They devised a manner of paying for goods with paper rather coin. Merchants who had sold goods to a buyer would, through the use of a written instrument, direct the buyer to pay a third person or payee. The merchant could then satisfy any indebtedness he owed the payee simply by handing him this written instrument. The payee could, in turn, use the instrument to satisfy an obligation of his own by signing it over to his creditor. Eventually, the written instrument would be presented to the buyer upon whom it was originally drawn. He would pay it, and thus a single instrument was used to sustain a number of payments without the need for gold and silver coin. The written instrument employed by the merchant came to be called a bill of exchange or a draft. A draft involved three parties. In our example, the merchant would be the drawer of the draft because he used the instrument to draw upon the debt he was owed by the buyer. The buyer, consequently, would be known as the drawee. The third person who received the draft and satisfaction of the merchant's debt would be the payee. When the payee signed and delivered the instrument over to his own creditor, we would say he endorsed and negotiated the draft. Over time, the medieval merchants developed customs and practices in handling bills of exchange. Because the bills were used as a medium of exchange, it was necessary to develop rules that made the instrument free transferable and that separated the obligation to pay a bill from the original transaction that gave rise to the instrument. The rules the merchants developed became known as law merchants and were applied across Europe in the mercantile courts. The law merchant made bills of exchange negotiable, that is, transferable by endorsement, free of claims and defenses arising from the transaction in which the bills were originally issued. By the beginning of the 18th century, English judges had incorporated the rule of the law merchant governing bills of exchange into the common law. By that time, as well, Parliament had sanctioned the negotiability of promissory notes. A note is a two-party instrument. The maker of a note undertakes to pay another, the payee. Notes evince an indebtedness the maker owes the payee. In the 17th and 18th centuries, notes were commonly used to make payments. Banks would issue their notes for coin deposited with them. Any bearer of the note could redeem it for specie, so the notes were valued for exchange. The 1702 Statute of N made notes negotiable by endorsement and delivery just like bills of exchange. Today, notes are rarely used in payment transactions. They still serve to evince debt. However, a buyer purchasing a home with a mortgage loan will sign a note as the maker or issuer undertaking to repay the lender as payee. If the lender then sells the obligation in the secondary mortgage market, it will have to take care to negotiate the note properly. It was during the 18th and 19th centuries, when bank notes and bills of exchange served as the principal means of making payments, that English and American judges developed the common law, regulating negotiable instruments. The courts emphasized the rights of good faith purchasers of these instruments in order to preserve their usefulness for making payments in the marketplace. Judges like Maud Mansfield and Joseph Story put the final touches on the holder in due course doctrine that remains a feature of the law today. The doctrine protects a good faith purchaser of a negotiable instrument from nearly all claims and defenses that would otherwise frustrate the purchaser's right to payment. It was also during the 19th century that Congress made its first efforts to regulate payments. During the first half of the 19th century, notes issued by state-chartered banks were used in commerce like money. Naturally, there were abuses. Shaky banks issued notes backed by little specie. Others directed that their notes would traverse dangerous backwood roads to obtain their species. As a result of these practices and the ever-present risk of bank failures, notes were discounted on the basis of the creditworthiness of the banks that issued them. A 19th-century merchant had to keep close track of how far a given bank's notes traded below par. Congress attempted to bring some order to this chaos after the Civil War. In order to favor the greenbacks issued by national banks, Congress enacted a discriminatory tax on state bank notes. The federal plan, like so much regulation, had unintended consequences. State banks staved off disaster by encouraging the use of checking accounts, and Americans have used them ever since as means of making payments. Because a check is simply a draft drawn on a bank, the common law of negotiable instruments applied to many aspects of the transaction. Check collections, however, were generally governed by private agreements among banks, which established elaborate correspondent relationships and fee structures to collect checks deposited with them drawn on other banks. The Uniform Commercial Code statutory antecedents. In 1882, Parliament codified many of the common law principles of negotiable instruments law in the British Bills of Exchange Act. The need for codification was even greater in the United States. During the 19th century, the federal courts had given a measure of uniformity to the American law of negotiable instruments. In this era, before the development of the Erie Doctrine, the U.S. courts fashioned a federal common law of negotiable instruments in diversity of citizenship cases. The federal courts simply did not decide enough cases, however, to prevent a marked lack of uniformity from developing in the American law of bills and notes created by the courts of the various states. In 1896, the National Conference of Commissioners Uniform State Laws, NCCUSL, moved to correct this state of affairs. NCCUSL sponsored the Negotiable Instruments Law, NIL, a uniform act modeled on the British Bills of Exchange Act. Every state eventually adopted NIL, the first model act to achieve this distinction. The NIL did not regulate check collections. Efforts to standardize check collections took place on both federal and state levels. The Federal Reserve Board, FRB, established in 1913, endeavored to make the check collection system more efficient. At that time, a bank presenting a check for payment outside its network of correspondent banks often had to pay an exchange fee. To avoid these fees, banks forwarded checks for collections over circuitous networks of correspondents. In one notorious example, a Birmingham bank seeking to cash a check at par value sent the check through many correspondents on a 2,260-mile, 7-day trip, though the check was drawn on a bank only 4 miles away. The Federal Reserve banks, on the other hand, exchanged checks at par value. When the FRB began permitting non-member institutions to clear checks through the Fed, exchange fees and bizarre collection routes disappeared. The Federal Reserve simplified the routing of checks by providing a more efficient, competing clearing mechanism. The FRB then had no regulatory authority over non-member banks. Fundamental questions concerning check collections had no uniform or even clear answer in state law. Efforts to craft a uniform state law for check transcribed by Mr. Difficult 80 on behalf of collections, however, did not enjoy the NIL's success. The American Bankers Association prepared the most successful model act, the Bank Collection Code, BCC of 1928, which 18 states eventually adopted. Significant changes in commercial practice, particularly the automation of check collection systems and the widespread use of electronic payments, led the Code's sponsoring organizations to recommend a revision of Article 3 and 4. In 1989, NCCUSL and the American Law Institute, ALI, approved a new Article 4A governing electronic fund transfers. In 1990, the Code sponsors also approved a new Article 3 and revised Article 4 were adopted in every state but New York. In 2002, the Code sponsors promulgated further amendments to the 1990 text of Articles 3 and 4. These amendments have generally been less well received by state legislatures than previous revisions. A dozen states have adopted the 2002 amendments, but the FRB has incorporated some of the proposals in federal regulations that have effect nationwide. This book describes the salient features of the 1990 version of Articles 3 and 4 and the 2002 amendments. In recent years, concern for consumer interests has led Congress and the federal regulatory agencies to enter the field. Too often, the holder in due course doctrine shielded sharp and deceptive sales practices. As a result, the Federal Trade Commission (FTC) adopted rules curtailing the doctrine's application in consumer transactions. Complaints from depositors that banks unreasonably delayed making funds available from deposited checks led Congress to enact the Expedited Funds Availability Act that took effect in 1988. That act required banks to make funds available for withdrawal soon after the deposit of a check. The act also expanded the FRB's authority over check collections. The FRB used that authority to assure that a bank that had accepted a check for deposit would receive prompt notice of its dishonor. In 2003, Congress enacted another piece of landmark legislation governing check collections. With the Check Clearing for the 21st Century Act, Check 21 Act, Congress adopted a framework that permits banks to truncate check collections. Traditionally, banks collected checks by physically transporting them from the bank of deposit to the bank on which they were drawn. The Check 21 Act gave banks a means of avoiding the transportation costs associated with bank couriers, trucks, and jets. The act permitted banks to convert a check into a digital image that could be forwarded to other banks for collection electronically. In addition to discussing federal law and its impact on contemporary check collections, this work will also review federal regulation of other modern payment systems. The use of credit cards as payment mechanism took off in the late 1960s when Bank of America introduced the Bank Americard, later known as Visa, and a group of banks created the Interbank Card Association that issued MasterCard. Federal regulation soon followed with the Truth in Lending Act, codified at 15 U.S.C. 1601-1667E, as Title I of the Consumer Credit Protection Act. The TILA gave the FRB regulatory authority over credit cards, which the board exercised in promulgating Regulation Z in 2011. That regulatory authority passed to the Consumer Financial Protection Bureau, CFPB, established pursuant to the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010, Dodd-Frank. Regulation Z remains the principal law governing credit cards and is the focus of Chapter 5. In the closing decades of the 20th century, innovative methods of accessing bank accounts led to a number of new ways of making payments. Banks offered their customers card access to 24-hour automated tellers, debit cards that could be used to make purchases, direct deposit of their salaries, and the ability to pay their bills by touch, tone, phone, and more modern means of communication like the Internet. While Article 4A of the UCC governed electronic transfers of funds between banks, federal law came to regulate these newer means of debiting and crediting consumer bank accounts. The primary federal state, the Electronic Fund Transfer Act, codified at 15 U.S.C. 1693-1693R, as Title IX of the Consumer Credit Protection Act, gave the FRB regulatory authority over automated teller cards, debit cards, payroll direct deposits, and other automated clearinghouse transactions. Dodd-Frank transferred this authority to the CFPB, which now administers the principal federal regulation implementing the Electronic Fund Transfer Act, Regulation E, United Nations Convention on International Bills of Exchange and International Promissory Notes on CBIP, United Nations Commission on International Trade Law and CITRAL. The General Assembly of the United Nations adopted UNCBIP in 1988 as part of its ongoing effort to establish universal norms for commercial interchange. Section 3102 of the UCC states that Article 3 applies to negotiable instruments. The code recognizes two general categories of negotiable instruments corresponding to traditional bills and notes. A three-party instrument where a drawer orders a drawee to pay another is called a draft under the code. A two-party instrument where the maker promises to pay another is called a note. If a bank promises to repay a sum deposited with it, the code calls the undertaking a certificate of deposit. 104J. If a draft is drawn on a bank and made payable on demand, the instrument is a check. 104F. In recent years, financial institutions have offered their customers a wide array of instruments to serve specific needs. These instruments include items like traveler's checks, which require a counter signature matching a specimen, cashier's checks, instruments drawn on a bank by itself, teller checks, instruments drawn by one financial institution on another, and personal money orders, which often are simply machine-embossed checks. Article 3 excludes from its scope transactions in money, meaning any instrument officially adopted by a government as a medium of exchange. The formal requisites of negotiability. Even though an instrument is styled as a draft or a note, it nevertheless must satisfy well-established requirements of form to be negotiable for the most part. These requirements date back to the law merchant. They are recognized internationally in Articles 1 through 3 of UNCITRAL language that closely follows that of the UCC. The UCC lists the requisites of negotiability in 3:104. A negotiable instrument is a 1. Signed. 2. Writing that states. 3. An unconditional. 4. Promise or order. 5. To pay a fixed amount of money. 6. To order or bearer. 7. On demand or at a definite time. And 8. Contains no other undertaking or instruction other than those allowed by the Code. The Treasury is the bank as they have pledged to pay all of your debts. 31 U.S.C. 3123. 18 U.S.C. Sec. 8 defines obligations. 31 U.S.C. 5312 seconds. 2. Shows we are all private bankers. A negotiable instrument must satisfy these requirements on its face. My fortunes is my face, sir. Form governs. One cannot contract for negotiability. A contract to pay money may state in boldface that it is intended to be negotiable, but if the writing lacks any of the required elements, it's non-negotiable. The Code devotes most of Part 1 of Article 3 to formal rules clarifying these requisites of negotiability. The sign requirement. In its definition of premises and orders that meet the standard of negotiability, 3103 requires that the person making the promise or giving the order sign the instrument. A writing is signed under 1:201, b. 37, if it is marked with any symbol intended to adopt or accept the writing. Thus, a signature may be a computer-generated graphic, a thumbprint, or an exit may be stamped, printed or written. The writing requirement. Section 3-103 requires negotiable promises and orders to be in writing. Section 1-201, b. 43, of the Code recognizes any international reduction to a tangible form as a valid writing. Negotiable instruments can be printed, handwritten, typewritten, or otherwise marked on any medium. The law outside the Code has changed. However, in 1999, the NCCUSL approved the Uniform Electronic Transaction Act UETA. UETA permits a payment obligation to take the form of a paperless electronic transferable record. UETA 16, 1999. In 2001, Congress enacted a narrower statute closely modeled on UETA, the Electronic Signatures in Global and National Commerce Act, ESIN. ESIN allows real estate mortgage obligations to take the form of electronic transferable records. 15 U.S.C. 7021, 2014. Because the law of negotiable instruments requires a token, it cannot accept oral negotiable instruments. The unconditional requirement. Section 3-104. The promise or order to pay money in a negotiable draft or note must be unconditional. Obviously, an instrument could not serve its transitional function as an easily transferable means of payment if it were encumbered with conditions. The requirement of a promise or order. A negotiable instrument must set forth either a promise or an order to pay money. Under 3-103. 9. A person signing a negotiable note must expressly undertake the obligation to pay. A document that merely acknowledges indebtedness, like an IOU, is not negotiable. It is good form to use the word promise in a note, although the courts have found similar language sufficient. Under 3-103. 6. The person signing a negotiable draft must give an order, that is, an unambiguous instruction to another to pay the instrument. The careful lawyer will use the verb pay in the imperative when preparing a draft. Banks and insurance companies often draw checks on themselves. In the case of the bank, such an instrument is known as a cashier's check. 3-104. G. Typically, the bank receives funds from a depositor who requests the cashier's check. On the face of the instrument, the depositor is generally identified as the remitter, with the issuing bank identified as both the drawer and the drawee. The 1990 revision of 3-103. 6 clarifies that one may draw a draft on oneself. It also permits a payee to be identified by another account number. Fixed amount of money requirement. A negotiable instrument must call for payment of a fixed amount of money, with or without interest or other charges. 3-104. The official comment to 3112 notes that this phrase means the principal amount of an obligation must appear as a sum certain in a negotiable instrument. Only an obligation payable in money can be negotiable. The general provisions of the code recognize as money and medium of exchange sanctioned by a government. Thus, instruments payable in pounds, francs, and euros are all negotiable. Because the code requires a negotiable instrument to state a sum certain, a blank check is non-negotiable. The code regards a check or other negotiable instrument where the amount line has been left blank as an incomplete instrument. The requirement that an instrument be payable to order or bearer a negotiable instrument must include words of negotiability. It must state expressly that it is either payable to the order of an identified person or to bearer 3109. Because everyone understands that checks operate as a payment medium and banks process the payment of checks through automated means, the current code does not require a check to state words of negotiability 3104. C. The payable on demand or at a definite time. Section 3104 requires that a negotiable instrument be payable either on demand or at a definite time. An instrument is payable on demand if it states it is payable at sight or use some other expression that indicates it's payable at the will of the holder. An instrument is also payable on demand if it states no time for repayment. 108. The instrument should state no other undertaking or instruction. The final requisite of negotiability in 3104 has a long history in the common law. To be negotiable, an instrument must not state any undertaking or give any instruction other than the promise or order to pay money. In the famous phrase of Chief Justice Gibson of the Supreme Court of Pennsylvania, a negotiable instrument must be a courier without luggage over Ron v. Tyler, 3 Pa 346, 1846. The holder in due course doctrine. The courts developed the holder in due course doctrine at a time when bills and notes served as the principal means of payment employed by commercial society. The doctrine separates the obligation to pay money evinced by a negotiable instrument from the transaction that gave rise to it. A person purchasing the negotiable instrument in good faith, the holder in due course, takes the instrument free of all contrary claims of ownership and virtually any defense to the payment liability it represents. The holder in due course under Article 3. Section 302 of the UCC tells us that a holder in due course is a holder, b. of a negotiable instrument which appears complete and authentic, c. who took the instrument in an ordinary transaction, d. for value, in good faith, and f. without notice that it is overdue, dishonored, part of a series in default, forged, altered, or subject to a claim or defense. Each element of the definition is important. How one becomes a holder, the process of negotiation. A holder in the parlance of the UCC is someone in possession of an instrument either payable to them or to bearer 201, b. 21, a. In most instances, the first holder of an instrument is the person to whom it is issued a marker or draw. He issues an instrument when he or she first voluntarily transfers it to another for the purpose of giving any person rights in it. 3105. 201, b. 15. Bearer paper, that is an instrument made payable to bearer or a check endorsed in blank, can be negotiated by delivery alone. Because no endorsement is necessary, a thief can negotiate bearer paper to a subsequent holder. One cannot be a holder in due course of a non-negotiable document. One cannot be a holder in due course in one's own right if the instrument is acquired at a sheriff's sale, by writ of execution, or through the use of some other creditor's proceeding. For most purposes under the UCC, value means common law consideration. The general definitions of the code define value as any consideration sufficient to support a simple contract. 204. Under Article 4 of the Code, a bank acquires a security interest in any check it takes for collection if 1. The bank has given its depositor an irrevocable credit for the item, 2. The depositor withdraws the credit, or 3. The bank either sets off or advances against the credit. 201. A holder in due course must give value for the instrument in good faith. Good faith is defined in the Code as honesty in tact and the observance of reasonable standards of fair dealings. 103, 6, or 201, b. 20. The term notice as used in the Code encompasses, but means more than, Actual knowledge 1202. A person has notice under the code if he or she receives mail or other communications at a place the person holds out to others as his or her address 1202. 2. The code will not allow the person who acts as an ostrich with its head in the sand to claim ignorance later. Checks are deemed overdue or state 90s after their started date even if they have not been presented for payment 304. 2. No one can be a holder in due course if he or she has notice of so fundamental a problem with the instrument as a forgery or alteration. A holder in due course of an instrument enjoys immunity from nearly all defenses and claims in recoupment arising from the transaction that generated the instrument. As one would expect, however, the code does not immunize a holder who has notice of a defense or claim. Few legal norms are more basic to a commercial law than the doctrine of derivative title. The doctrine, often called the shelter principle, holds that when a person transfers something to another, the transferee acquires all the transferor's rights. Any transfer of a negotiable instrument vests the transferee with all the transferor's rights. If a holder in due course transfers an instrument to another but neglects to endorse it, the transferee will nevertheless enjoy the rights of a holder in due course under the doctrine of derivative title. The transferee can take shelter in the transferor's title. A holder in due course takes an instrument free from virtually all contrary claims audit. Under 3306, these claims would include contrary claims of ownership to the instrument or its proceeds, and lien claims arising in law or in equity. A holder in due course also takes the instrument free from any claim in recoupment arising from the transaction that generated the instrument 3305. 3b. A holder in due course is immune from nearly every defense that arises in a typical commercial transaction 3305. 2b. Fraud in the inducement, failure of performance, misrepresentation, payment, and most other defenses fail against the holder in due course. Under the Geneva Uniform Law on Bills of Exchange, holders generally enjoy even greater immunity from claims and defenses than the common law holder in due course. The convention affords considerable protection to protected holders. It's easier to attain the status of a protected holder than it is to attain a UCC holder in due course. Generally, a protected holder must hold a complete or completable instrument by negotiation that is not overdue and must have knowledge of a claim or defense to it. The definition does not require the giving of a value and does not impose a general obligation of good faith. A protected holder need only show that he did not obtain the instrument by fraud or theft or participate in the fraud or theft concerning it. Unsabib, at 29e. The code encourages prompt presentment of checks. If a person does not present a check or deposit it for collections within 30 days of its date, the code relieves any prior endorser from liability on the instrument 3415e. An endorser can endorse an instrument for the purpose of transferring the title to it but without incurring contractual liability. This is done by endorsing the instrument without resource 415b. Check 21 Act permits banks to process digital images of paper checks. All checks have a strip of magnetic ink characters encoded across their face along the bottom. These characters are known as the MICR line. The initials stand for magnetic ink character recognition. The MICR line can be read by machine and thus allows for automated processing of the great volume of checks exchanged each day. Most of the information needed to process a check is pre-printed. The pre-printed MICR characters give the routing numbers for the drawee or payer bank. The routing numbers are a code also printed as a fraction in the upper right-hand corner of a check. They must also include the customer's account number and check number. Only the amount needs to be encoded at the depository bank. Generally, settlement must occur by midnight of the banking day the item is received for. 302. 1. A clearinghouse is an organization of local banks in which the banks agree to exchange the checks their customers draw against and to one another every day. The exchange can be made a central location, thus eliminating the need for couriers to run around town all day. Settlement can occur through the clearinghouse where all the checks drawn on the members can be netted against all the checks made payable to customer accounts held by the members. If at the end of the day, a member bank owes more to the other members than the member bank is due from them, the member bank can settle with a single transfer of funds to the clearinghouse. The New York clearinghouse exchanges millions each day. A payer bank can dishonor a check under UCC by returning it or sending written notice of dishonor to the person who presented the check for 301. Under the code, a bank could satisfy this obligation simply by dropping the dishonored check in the mail after stamping it NSF, not sufficient funds, or giving some other reason for its dishonor. C1, 201, B, 36, A. Regulation CC. The regulation requires banks dishonoring or returning checks to make expeditious returns 12 CFR 229.30. A surety is always entitled to indemnification or reimbursement for any amounts the surety pays the creditor. The Code expressly preserves that right for accommodation parties 3,419 F. Upon paying the creditor in full, a surety at common law was subrogated to the creditor's rights against the principal. These rights could include a security interest in collateral belongings to the principal. An accommodation party may raise a claim in recoupment belonging to the principal up to the amounts of the instrument 3,305 D. A claim in recoupment is a claim that arose from the same transaction that gave rise to the instrument. Every mortgage transaction creates two legal interests. The first is the obligation to repay the mortgage loan, typically embodied in a mortgage note. The second is the interest in real property the lender obtains to secure the mortgage. In most American jurisdictions, this interest is a lien that is perfected by filing a record of the mortgage with the county recorder of deeds. If the mortgagor defaults in repaying the mortgage debt, the lien holder can foreclose upon the mortgage. If the mortgagor files bankruptcy, the mortgage lien holder will have a secured claim equal to the amount of the unpaid debt or the value of the property subject to the lien, whichever is less. Thus, every mortgage generally has a valuable stream, the sums payable on the note, and useful collateral in the event of default or bankruptcy, the mortgage lien. For this reason, mortgages have been attractive vehicles for securitization. In a securitization, large numbers of mortgages are assigned to an entity that issues securities backed by the mortgage obligations. Lawyers structuring these transactions must assure that the entity is the holder or person entitled to enforce the mortgage notes. However, otherwise, the entity is not entitled to either the payments on the notes or the right to foreclose on the underlying mortgages. In Price v. Neal 32 Bur. 1354, 1762, Lord Mansfield decided that a drawee should know his drawer's signature and should therefore bear the loss if the drawee pays a draft bearing a forgery of the drawer's signature. At one time, banks routinely examined their customers' specimen signatures before deciding to pay a check. Today, they rarely do. Authority can rest on any doctrine recognized by the law of agency 3402. A person found negligent under 3405 can shift a portion of the possession to other negligent parties on a comparative negligence basis. In all instances, the burden of proving another's negligence lies with the party asserting it 3405. C. In 2010, the FRB eliminated the distinction between local and non-local checks by making the Cleveland Federal Reserve Bank the sole check process center in the country. 12 CFR Part 229. App A in general. The Expedited Funds Availability Act and Regulation CC require funds to be made available quickly when the risk to the bank of dishonor is low. Thus, cash deposits, electronic funds transfers, funds credited against government checks, certified checks, official bank checks, and checks drawn on the depository bank itself must be made available to a depositor the next banking day following the deposit. The question of reasonable certainty is one of fact. The right to subrogation has its roots in equity. Regulation Z continues to be the chief federal law governing credit cards. Tragically, the shortcomings and vulnerability of a paper-based payment system heavily reliant on air couriers became painfully evident with the events of September 11, 2001. Congress responded by enacting the Check Clearing for the 21st Century Act, also known as the Check 21 Act. When the Check 21 Act took effect in 2004, all checks collected through the Federal Reserve System were paper. By 2013, over 99% of the checks collected through the system were deposited with the FRB in electronic form. The efficiency of electronic check processing has allowed the FRB to close 44 of its 45 check processing centers and to treat all collection items as local checks for the purposes of expedited funds availability.